Hello, everyone, and welcome to HR Options Canadian Employment Webinar. My name is Nunzio Presta, and I am responsible for sales operations and marketing for HR Options Canada. It is my pleasure to be your moderator for today's session. Today, we will be learning from my colleagues, Catherine Benson and Stacey Glass. Catherine and Stacey have both been with HR Options for well over 10 years and work with a wide array of companies, ensuring that our clients are compliant with employment laws and HR policies across Canada, as well as outsource employment, recruiting, training, and HR policy development. At HR Options, we provide HR consulting and outsource employment throughout the US and Canada. We've been doing this for over 25 years. If your organization is new to employment in Canada, HR Options can provide Canadian HR support, or if you're not ready to take on the Canadian employer role, let us be the employer for your companies throughout Canada. So be your workers on our payroll. It's always nice to have options, and that's what HR Options is all about. With regards to today's webinar, you're welcome to type in any question by clicking the question icon found at the top banner throughout the session, and we'll answer as many questions as we can at the end of the webinar in our Q&A session. If we don't have time to get to your questions, I welcome you to reach out to Stacey, Catherine, or myself for more information about the webinar when it's over. We'd love to hear from you. And with that said, let's get things started. Catherine, take it away.
Great, thanks, Nunzio. So welcome everyone to HR Options webinar. Stacey and I are really happy to be presenting today's topic, a crash course in Canadian employment. So our goal today is to give you as much information as we can and to review the Canadian employment environment and also highlight changes that occurred in 2018. Our topics today include employer payroll taxes and remittances, employee leaves and how to pay employees in accordance with employment standards, drug and alcohol testing, public health care versus employer-sponsored benefit plans, employment agreements, how to end an employment relationship, anti-harassment legislation and training requirements, and some recruiting trends and employment options in Canada. And of course, like Nunzio said, if we don't cover a topic you're interested in, please reach out directly for more information. We would love to hear from you. So with that, let's get started. So many new employers in Canada that we've worked with have mistakenly thought that they are federally regulated by the Canada Labour Code, when in fact only 10% of industries in Canada fall under federal legislation. So I wanted to briefly cover what's governed by provincial versus the federal government. Each province has control over employment standards legislation, so things like minimum wage, vacation pay, leaves, etc., workers' compensation boards, and health and safety, and lastly over human rights legislation. So that's all the province has control over. In contrast, the federal government has control over employment insurance programs, with the exception of Quebec, who administers their own EI program. And for specific industries only, such as banks, air and marine transportation, and telecommunications, the federal government legislates employment standards through the Canada Labour Code and administers workers' compensation and health and safety regulations. Most of you listening today should refer to the provincial regulations where your employees work, and the rest of today's webcast will apply to provincially regulated companies. It's important to note that each province, like each state in the U.S., has its own interpretation and laws for employment standards. So now that we're all on the same page in terms of jurisdiction, let's turn to payroll taxes and remittances. So if you're new as an employer in Canada, to set up, you'll obtain a business number from the Canada Revenue Agency, known as the CRA, and register for a payroll and sales tax account. And you'll need to register with the Provincial Workers' Compensation Board where your employees are working. Once you start to pay your Canadian employees, the payments to be remitted to the CRA include your employer-paid portion of the Canadian Pension Plan, called the CPP, which is 4.95% of salary, the employee-paid portion of the CPP, which is also 4.95%. You'll also pay the employer-paid portion of employment insurance premiums, called EI, to Service Canada, which is 2.324% of salary, and the employee-paid portion of EI, which is 1.66%. And all these percentages that I'm mentioning, I've put on the slide, and they reflect 2018 rates. And of course, you'll also, as the employer, remit the employee paid federal and provincial income taxes to the CRA. Some provinces also charge an employer paid and an employee paid health tax, such as in Ontario. As noted on the slide, Quebec administers their own pension and employment insurance plan, so they have slightly different rates, so please reach out if you need more information on Quebec. The employee's income and deductions are reported on a T4 at year end, which, if you're a listener from the U.S., is similar to the W-2 in the U.S. And in Quebec, you also have to report using what's called a relevé that is submitted to Revenue Quebec. And just a tip, if for employees who cover their own expenses throughout the year or work from a home office, you'll also provide a T2200 form at year end. Next, an important tax to consider if you are doing business in Canada is the goods and services sales tax. So this may apply when you sell your services in Canada or when you use a Canadian vendor who is selling you services or products. The federally regulated goods and services tax, known as the GST, is set at 5%, and then each province regulates provincial sales and services taxes that may be charged on top of the 5% GST. Some provinces, such as Ontario and Nova Scotia, have harmonized the federal and provincial sales tax into one lump sum called the HST, while other provinces maintain a separate system for federal GST and their provincial portion of the sales tax. So I won't go through each example that I've listed on the slide because that's an entire webcast in itself, but I just wanted to give you a heads up to speak with a financial advisor regarding how GST, PST, or HST will impact your business in Canada. An experienced accountant can also help you look at zero rating categories, meaning you can be exempted from charging or being charged sales tax by your Canadian vendors only under certain conditions. So in order to be zero rated from sales tax, you must be considered a non-resident under Canada's Excise Tax Act, meaning you have no permanent establishment in Canada, so no fixed place of business, including a place of management, a branch, an office, or a workshop, or any place of extraction of natural resources. However, you could have an independent agent acting on your behalf in Canada. So, for example, if you're a U.S. company and you just want to hire a Canadian employee to work from a Canadian home office, you can use the services of an outsourced employer, such as HR Options, without it affecting your non-residency status. And again, just for our U.S. listeners who are listening, if you want more information on this, we can definitely refer you to a tax expert. And with that, I'll pass it over to Stacy, who's going to start our talk on how to pay your employees in accordance with employment standards legislation.
Great. Thanks, Catherine. Our next topic is pay and hours of work. First, I just want to review the minimum wage laws in Canada to bring us all up to speed. So some of the lowest rates seen in Newfoundland and Labrador at $11 an hour, and one of the highest minimum wages is in Ontario, where effective January 1st, 2018, it's $14 an hour. And it's going to be increasing to $15 an hour as of January 1st, 2019. And Alberta is also following suit and increasing to $15 an hour in October 1st of 2018. So to give some examples from other highly populated provinces, the minimum wage in British Columbia is $11.35 per hour, but again, it's going up to $12.65 as of June 1st, 2018, and it will continue going up each year. And in Quebec, it went up on May 1st, 2018, to $12 per hour. So please note the legislated increases listed on the slide, and it's a good resource if you want to keep note of it, is the Retail Council of Canada website. They tend to keep really up to date on minimum wage changes. Note there are some exceptions to minimum wage in most provinces for students or employees serving liquor and home workers, among others. So please see the Provincial Employment Standards Act or Code where your employees are located to determine if an exemption applies to your staff. Provincial employment standards legislation covers everything from termination requirements to minimum wage. But what I want to discuss now is the overtime rules, which are staying constant for 2018. Like most employment standards, overtime varies per province. Throughout the webinar, we're going to give you examples from across Canada to highlight some of those differences. However, you have to be sure to investigate what applies to your employees by going to the provincial websites where your employees are working. Generally, the overtime rule is 1.5 times the employee's hourly wage for hours in excess of the weekly or daily maximums. For example, hours worked in excess of 40 hours per week would be considered overtime in BC and Quebec, 44 hours per week in Alberta and Ontario, and anything over 48 hours in Nova Scotia. However, note that Alberta has daily maximums of 8 hours per day as well as weekly maximum of 44 hours. So in this case, you pay overtime on whichever amount of overtime, daily or weekly, would be a greater benefit to the employee. There are also double time rules for employees working more than 12 hours per day in BC. If the employee is paid via incentive pay, so piecework or commissions, minimum wage is used to determine overtime pay. Just note that the definition of wages also varies per province when determining the rate of overtime. Some provinces include vacation pay for overtime like Saskatchewan, and others don't, like Alberta. Under the new Ontario legislation in 2018, employees who hold more than one position with an employer and who are working overtime must be paid at the rate for the position they are working during the time of overtime that the overtime was used. There's not enough time for me to go over it today, but I'd like you to be aware that there are options if you do require a lot of overtime. You could implement averaging agreements, or you could develop agreements with employees to take overtime off as banked time. So there are other options to paying out overtime if your employees agree to it and if you follow the correct employment standard guidelines. In all provinces, overtime applies to full-time, part-time, and student employees. Overtime is also applicable whether an employee is paid hourly or salary. So in Canada, we don't generally use the terms exempt versus non-exempt as much or as commonly as in the U.S., but rather most employees are eligible for overtime pay if they are even if they're salaried. So the only reason someone wouldn't receive overtime pay is if they meet specific requirements. For example, employees whose job duties qualify them as true managers wouldn't qualify for overtime in Ontario and most other provinces. Exemptions from certain employment standards in Canada are based on what the employee is actually doing, so their duties, and not necessarily by their title. So I've added some links to this slide for your reference to some special exemption rule tools to determine if your employees would be considered exempt. And if you have employees in another province not listed, just feel free to reach out to Catherine and I for more information. In Ontario and Quebec, overtime does apply to travel hours. All work hours, even travel hours, fall under normal hours of work regulations, where exemptions don't apply, like we discussed on the last slide. Also, in Ontario, commuting time and travel during the workday are treated differently under the Employment Standards Act. Commuting time is the time it takes an employee to get from work to home and vice versa. This is not counted as work time for the purposes of the Employment Standards Act. However, there are a number of exceptions to this rule. So, for example, if the employee takes a work vehicle home in the evening at the employer's request, work time begins when the employee leaves home in the morning and ends when he or she arrives home in the evening. Also, if the employee is required to transport other staff or supplies to or from the workplace or work site, that time may be counted as work time as well. And next, if the employee has a usual workplace but is required to travel to another location to perform work, the time traveling to and from that other location is counted as work time in both Ontario and Quebec and in most other provinces. Be careful to check the regulations for employees exempt from overtime regulations, such as managers. They are probably eligible to be paid for their travel time, but the overtime calculations don't apply. Again, refer to today's handout to see specific rules in the province that you're interested in. This next slide on public holidays has a lot of information, and it's really meant to be a reference for you after today's webcast. Firstly, all statutory, also referred to in many provinces as public holidays, listed on this slide must be paid to employees under the Employment Standards Act of each province. For each holiday, the slide shows which provinces mandate that you pay for the holiday. However, there are cultural norms and special rules, some of which I've highlighted on the slide and a few that I'll just speak about right now. So for example, Boxing Day, which is the day after Christmas, and the August civic holiday are not official statutory holidays in most provinces, but many companies provide it as a paid day off for employees. Also in Quebec, often January 2nd is provided as a holiday as well. So keep in mind if you choose to honor one of those extra days as additional holiday for employees, despite the extra day not being officially listed in the Employment Standards Act, all rules pertaining to that general holiday will apply to that day if you deem it as a holiday for employees. So if they work the holiday, they will be entitled to premium pay. So just keep that in mind. In regards to payment of holidays, again, it varies per province, but if an employee agrees to work on the public holiday, you generally have to pay them for the day worked and a premium pay of another full day and a half. So, for example, an 8-hour day employee would get 8 hours for the day worked on the public holiday and another 1.5 times that day, so another 8 plus 4 hours for a total of 20 hours for the day. Alternatively, with employee consent, you can provide them with another substitute day off work in lieu of the holiday, of course, depending on the province you're in and the legislation there. The new Employment Standards Act legislation in Ontario, effective January 2018, makes the holiday pay calculation sort of easier than it was before, where the calculation divides the wages earned in the pay period immediately preceding the public holiday by the number of days actually worked in that period to come up with what the wages were for that public holiday. However, there has been, I think, a lot of employer complaints about how much they have to pay their part-time people using that method, and so the government has now is looking at retracting that. And as of July 1st, it's going to go back to the previous method where it's taking the 4 weeks prior to the holiday and dividing those wages by 20. Also, with this new legislation, they did say that in some places there may not be a pay in lieu of a holiday. So again, you need to check your legislation, and also keep an eye out if you employ in Alberta, as they have made several changes to the Employment Standards Code as well, including holiday pay moving to a 5% of wages in the last 4 weeks calculation, and the elimination of regular versus non-regular workdays. So in terms of who's eligible for public holiday pay holidays, most provinces will list a time period that an employee must have been employed before being eligible for that holiday pay. So for example, in BC and Nova Scotia, the employee must have worked 30 calendar days before the holiday and have worked and earned wages in 15 of those 30 days before the holiday. Whereas in Alberta, Ontario, and Quebec, for example, it doesn't matter how long the employee has been with the company, they're entitled to the holiday, but the pay is prorated based on those calculations from the previous slide. So many provinces, including Ontario, say the employee must have worked their last scheduled shift before and the first scheduled shift after the holiday to be paid for the holiday. But a word of caution here, be aware that employees will remain eligible for the holiday pay if they have the employer's permission to be absent for either either one of those shifts. So for example, because of vacation or sick time. And lastly, to qualify for holiday pay in most provinces, the employee must not have refused to work on the general holiday when asked to do so. Some common jobs that are exempt from any holiday pay include agricultural workers, managers, some commission sales people. But again, check your province using the links that we've provided in today's handout to be really sure about your situation. And now I'll pass things back to Catherine to review vacation pay.
Perfect. So the most important thing to remember is that vacation time and pay applies to salaried, hourly, full-time, part-time, student, and contract employees. Vacation normally starts at 4% of gross earnings, or 2 weeks per year, but some provinces legislate mandatory increases in vacation, as I've listed on the current slide. Keep in mind that in reality, the norm for many professional positions is to start employees at 3 weeks of vacation per year. So when you're recruiting, if you want to stay competitive, you might want to go above what the minimum legislation says. How vacation is paid can often be a source of confusion to companies in Canada. So vacation rules and exemptions vary per province, but to highlight a common example, I'll use Ontario, whose legislation is very comparable to the other provinces. In Ontario, the legislation covers vacation time and vacation pay. For vacation time, employees are entitled to 2 weeks time off after 12 months of work. But keep in mind that the norm is to allow time to be used as it is accrued. In addition to that time off, employees are entitled to at least 4% of their gross wages earned in the last 12 months paid as vacation pay. It's important to note that gross wages may include regular pay, bonuses, public holiday pay, commissions, overtime, termination pay, etc. So as you'll see is a common theme in our webinar, check which province your employees are in to determine what the legislation says to define gross wages. And at least 4% vacation pay should be paid on all those types of compensation that are included in the definition of gross wages. To make your life easier, many companies pay employees through their vacation and track it, as well as pay their 4% or 6% on any additional payments such as bonuses and commissions at the time of payment. So you know that by year end, you've met all the regulations in the legislation. Lastly, remember that you must pay out all accrued and unused vacation to a terminated employee up to and including their last day of work. Next, we often get asked if it's normal to allow employees to fall into a negative vacation accrual. So, for example, if an employee has only worked for 6 months but asks for their full 2 weeks of vacation time off, in this case, the employee would fall 1 week into a negative accrual and not quote unquote climb their way out of that negative accrual until year end. In truth, for professional level positions, many employers allow negative accruals and trust that the employee's accrued time will balance out. However, of course, if you have high turnover, we would not recommend allowing negative accruals since it's normally not allowed in Canada to deduct any funds from an employee's pay, including negative vacation accruals. A practical solution is to implement a negative accrual cap. So, for example, your policy can state that with management approval, and if it does not interfere with workflow, employees are entitled to fall into a negative vacation accrual of no more than 5 days before vacation requests will be denied until vacation days are accumulated. To answer another common question that we get, you can carry vacation accruals to a new year, and you can cap how much an employee can carry over to a new year, so long as the cap does not interfere with the employee receiving their minimum vacation entitlement under employment standards laws, or whatever is written in the employee's employment contract. Lastly, it's important to know that employees on unpaid protected leaves of absence, such as sick leave and maternity leave, will continue to accrue seniority and unpaid vacation time. However, they would not be entitled to vacation pay for that time on unpaid leave. Here, it's really important to be very careful how you word your vacation policy and how you outline vacation pay in your employment agreements. If you indicate that employees are entitled to a flat 2 weeks paid vacation every year and you don't link vacation pay to their accrued earnings, you may have an employee on a long-term leave asking for their paid 2 weeks vacation every year despite the fact that they have no earnings and they would in fact be entitled to that pay. Instead, word your policy along the lines of: you will be entitled to 2 weeks or 10 days vacation time per year earned at an accrual rate of 3.08 hours for every biweekly cycle actively worked. That's my example. Of course, you would tailor that to your pay cycle and how much vacation you're providing. But that's a top tip we like to give everyone because it's often overlooked in policy development. Now I'm going to take you through job-protected leaves of absence in Canada. And when I say job-protected leaves, I mean eligible leaves that fall under human rights or employment standards legislation that an employer must allow employees to take. However, the employer is not required to pay the employee throughout the leave. This slide highlights some protected leaves for your reference, but I'll specifically be looking at pregnancy and compassionate care and some other leaves that raise a lot of questions in Ontario. Before I get into my specific examples, human rights legislation gives 3 specific rights to employees on protected leaves. One is the right to reinstatement after the employee's leave to the same job or comparable job if that same job no longer exists, and the right to the same pay or increased pay if it went up while the employee was on leave. The right to be free from penalty or discrimination from the employer for taking the leave, and employees have the right to continue to participate in benefit plans while on the leave. So, for example, pension plans or extended health and dental plans. The first leave I'll review with you is pregnancy leave. And again, for those of you listening in from the U.S., this leave often surprises a lot of our U.S. listeners because it's so different in Canada. And as usual, leave legislation varies per province, and in this case, Quebec is the most generous. but it was the most generous, I should say. But effective in 2018, Ontario and Alberta are also offering a lot more time off for parental leave. In general, pregnant mothers can take between 15 and 18 weeks unpaid pregnancy leave across the provinces, and on top of this, 35 to 37 weeks unpaid parental leave. So generally, 52 weeks total. However, in Quebec, mothers can take up to 52 weeks unpaid parental leave on top of their pregnancy leave, and effective 2018 in Alberta, mothers can take up to 62 weeks parental leave. In Ontario, mothers can take up to 61 weeks parental leave on top of their maternity leave for a total of a year and a half of leave. Fathers, adopted parents, and guardians don't get the 15 to 8 weeks maternity, also known as pregnancy leave, but they can take up to 37 weeks of unpaid parental leave. Again, in Quebec, this parental leave can extend to 52 weeks, in Alberta to 62 weeks, and in Ontario to 63 weeks. Quebec also grants fathers 5 weeks unpaid paternity leave on top of their parental leave. To qualify, employees must be covered by employment standards legislation, which 99% of you who are listening today qualify under. An example of an employer exempt from employment standards would be law firms who are self-regulated. Also, to qualify, generally the employee has to be hired for a specific time frame before the start of the leave. Again, you'd have to check which province your employee's in. However, please note that the employee doesn't have to actively work that time frame before the start of the leave. They can be off on sick time, and this counts as active work. A final note of interest here is that since the leave is not paid by the employer, employers taking this leave and any other leave that falls under employment standards receives employment insurance benefits from the government, which for maternity leave are 55% of the employee's salary to a maximum of approximately $543 per week for the 52-week period. And again, the formula is a little different in Quebec, and within Ontario and Alberta's new rules, the formula will be different for those employees extending past the 52 weeks. So, as an employer, if you don't have to pay your employee while on leave, what do you have to do? As the employer, you have to provide an employee going on leave with their record of employment, known as the ROE, which you can access via Service Canada. And note that paper copies have been phased out, so you must enroll online with Service Canada to issue the ROE. The employee then takes this to Service Canada, or if you did it online, when you hit submit, Service Canada automatically gets a copy of the ROE, and then Service Canada reviews the ROE and decides what employment insurance benefits are payable to that employee through their leave. And for more information on employment insurance, you can visit Service Canada at servicecanada.gc.ca. Next, the Federal Canada Labour Code and most provinces allow employees to take unpaid job-protected leaves for family medical, also known as compassionate care leave. And to qualify for this leave, the employee must need to care for a specific family member or someone the employee considers to be like family who's at risk of dying in a specified time period. The employee must provide a certificate from a doctor to the company indicating the family member who's at risk of passing away in the next, for example, 26-week period. As usual, the leave does vary per province, but in general, BC, Ontario, and Nova Scotia for a full-time, part-time, or contract employee can take up to 8 unpaid weeks in a 26-week period, and in Quebec, an employee can take 12 weeks in a 12-month period, and in Alberta, the leave has been extended to 27 weeks. The weeks of leave don't have to be taken consecutively, and if illness continues, your employee can reapply for more time. And again, since the leave is unpaid, the employee can apply for government employment insurance benefits called compassionate care while on leave. These next slides address a common confusion, and we often hear our clients and employees confusing Ontario's personal emergency leave with family medical or compassionate care leave. In fact, there are two different types of leave. Unlike family medical leave, which we just discussed, personal emergency leave is unpaid, except for 2 days now in Ontario, job protective leave that the employee can take every calendar year. And this includes employees who start halfway through the year. They'd still be entitled to their full 10 days under personal emergency leave. With Ontario's new employment standards rules in 2018, employees who have been employed for at least 1 week will now be entitled to their 10 days, and like I just said, 2 of those days must be paid days under personal emergency leave regulations. Personal emergency leave can be taken for personal injury or illness or an urgent matter relating to themselves or certain family members. Qualify, the medical situation does not need to be imminent risk of death or to care for an ill family member like other leaves. Also, prior to 2018, to qualify, an employee had to work for an employer with 50 or more employees, but with the 2018 changes, this requirement was removed. Next, the list of people for whom a family medical leave can be taken is not identical to the list specified for personal emergency leave. The list is more restrictive for personal emergency leave. Also, an employee can use this leave for pre-scheduled surgeries so long as the surgery is not cosmetic and is actually to treat an illness or an injury. We often get asked if an employee is entitled to the leave, even if the injury was caused by their own carelessness, such as an employee trying to barefoot water ski at their cottage on the weekend. And the answer is yes, they would be entitled to the leave if all other qualifiers exist. So be aware that an employee who qualifies for both leaves, such as family medical and personal emergency leave, would have full entitlement to each leave and the protections that I discussed at the beginning of this section. And quickly, before we move on from personal emergency leave, I just wanted to review the definition of urgent matter a bit more, since this vague language in the Act is really what gets under most employers' skin. An urgent matter is an event that is unplanned or out of the employee's control and raises the possibility of serious negative consequences, including emotional harm, if not responded to. So an example of an urgent matter that would qualify under personal emergency leave is that the employee's babysitter calls in sick and they can't get coverage. That would count. Or that the house of the employee's elderly parent is broken into and the parent is very upset and needs the employee's help to deal with the situation. That would count under the leave. Or the employee has an appointment to meet with their child's counselor to discuss their behavior at school, and an appointment could not be made outside of working hours. That would count under the leave. What would not count as an urgent matter is if an employee wants to attend their brother's or sister's wedding, or they want to go see their daughter's track meet, for example. That would not count. Lastly, another common question we receive is how to integrate your employer sick day policies with personal emergency leave. The rule is that if an employment contract provides a greater right or benefit than the personal emergency leave standard, then the terms of the employment contract apply. However, if the contract does not provide a greater right or benefit than the personal emergency leave standard, then, of course, the personal emergency leave provisions will apply. They will get their 2 paid days off under the legislation. It's also important to understand that the Ministry of Labour will not get involved in determining how the leave provisions of the contract are applied. It's up to you as the employer to ensure that you abide by the policies you have in place, so long as they don't provide less than what the legislation says. And I would recommend, if you're already as an employer providing paid sick days, let's say you provide 3, 5, or 7 paid sick days to your employees per year, just adjust your policies to make it clear that if you're in Ontario, that the 2 paid personal emergency leave days are included in those paid days that you're already providing. So employees don't think they get your 5 paid sick days plus another 2. Finally, to wrap up my section on leaves, Ontario has some unique leaves. Ontario has the most leaves across Canada, and some of which were new under the 2018 updates. So there's domestic and sexual violence leave, critical illness leave, both are new, and Ontario also has critically ill child care leave and crime-related death and child disappearance leave. So hopefully no one ever has to use any of those. There's a summary of the legislation on the slide for your reference, and at the end of today's webcast, we do have a bunch of slides that summarize all of the updates in Ontario because there were so many. And now I'm going to pass it over to Stacey to discuss drug and alcohol testing.
Great. Thanks, Catherine. Drug and alcohol testing is rare in Canada, and in most cases, it's not worth the legal risk to do them. However, there has been some Canadian cases that confirm the following scenarios where drug and alcohol testing would be permissible. So, firstly, in safety-sensitive positions where an accident or incident has occurred, as part of a post-treatment monitoring program in coordination with your employee, as a condition of continued employment after a drug and alcohol policy violation has occurred, and finally, we see it a lot as the pre-employment testing, meaning prior to the employee's appointment to a safety-sensitive position or pre-access to a safety-sensitive site. Safety-sensitive meaning that being under the influence could cause irreparable damages or death. So the key to note here is it truly has to be a safety-sensitive position or safety-sensitive site to warrant a pre-employment drug or alcohol test. And the testing would take place after the employment offer has been made to the employee. In some provinces, it's not the actual tests you administer that are discriminatory. You can do them. It's what's done with a positive result that raises concern for the Human Rights Commission. Specifically, that you must accommodate for any employee you test that produces a positive result and is deemed to be dependent on drugs or alcohol. So some things that you should be doing to ensure that you're not violating employee rights includes having a solid and well-defined drug and alcohol policy in place. This includes why you have it, who it applies to, how testing will work, what happens in the case of a positive result, employees' right to privacy, definitions, discipline, accommodation and rehabilitation stipulations, and lay out what the employee can expect from the company and the company's expectation of the employee in regards to drug and alcohol at the workplace. Ensure employees are aware of your policy. It's always a good idea to have employees sign off an acknowledgement on your policies on a regular basis, at least yearly. Identify the risks of partaking in drug and alcohol use at the workplace. So, for example, list the dangers to employees and their colleagues. Also, assist however possible to prevent drug and alcohol incidents. So, for example, try offering education sessions on these topics. If you're contemplating the adoption of testing as part of a drug and alcohol policy, you will also need to take into account that the burden is on you, the employer, to show the courts that the testing is necessary to the job. You should also realize your obligation to demonstrate the reasonableness of the tests, and it is your duty to accommodate employees who fail those tests and are suffering from drug abuse or addiction problems, including alcoholism, to the point of undue hardship. There has been some movement to randomized testing, but it's under very limited circumstances, and again, only under safety-sensitive positions. So, for instance, the Toronto Transit Commission recently adopted random testing of its drivers. Over the last, first 3 months of their testing, 17 of the 680 tests came back positive, and the TTC now has an obligation to determine if those who tested positive have an addiction that requires treatment and reinstatement, or if it was actually a breach of policy and they need to terminate. Also note that marijuana is becoming legal in Canada sometime in the near future. They originally said July 1st, but that looks like it's been pushed forward a bit. You may want to revisit your drug and alcohol policies to ensure your policies are still compliant. In keeping with medical theme, I'm now going to talk about health care benefits. I often get asked by a lot of our U.S. clients why a Canadian employer should provide benefits when Canada has a public health care system. And the truth is, although some services are covered through provincial governments, many benefits are not. So each province and territory in Canada has their own public health insurance plan. So for an example, in Ontario, it's referred to as OHIP, in Quebec, it's called RAMQ, and in Alberta, it's Alberta Health and Wellness. I'll be referring to OHIP today to keep things simple, but each province's health insurance plan covers different medical necessities, but overall they're very similar. As with most health insurance plans, OHIP doesn't cover any services that are not medically necessary. So for example, optional plastic surgery would not be covered. On top of that, public health care also won't cover most prescription medications, dental care, long-term disability, or eye care for most people. Again, there are variations between provinces and variations based on employee circumstances. Generally, the provincial plans will only cover regular and specialist doctor visits, government-approved immunizations, hospital stays, surgeries, and emergency hospital care. For this reason, to remain competitive in the Canadian market, you should be offering a supplemental benefit plan for employees. Canadian employees will expect a benefit package as part of their employment. So a typical employer-sponsored benefit plan would cover the basic benefits not covered by the province's public health insurance plan. So for example, a typical plan might include medical coverage, maybe 80 to 90% of prescription drug coverage, semi-private hospital room instead of a ward room, and paramedical services like massage therapy or chiropractic for between $300 to $500 per year. For dental, usually there's 80% coverage for basic treatments and 50% for major treatments up to a maximum per year. And competitive plans will also offer vision care, long-term disability, travel insurance, life insurance, and accidental death and dismemberment, usually at 2 times the employee's salary. So please keep in mind that life, dependent life, and accidental death and dismemberment, as well as critical illness premiums and the applicable taxes to those for coverage paid for by the employer on behalf of the employees, are a taxable benefit to the employee. And in Quebec only, medical and dental coverage that are employer paid are also taxable to the employee. We would be happy to recommend a great benefit broker if you're looking into a plan or want to revise or save costs with your current plan. An approximate cost for an employer-sponsored benefit plan would be between $200 and $250 per month per employee. That depends on plan coverage. That's really mostly for a single person on single coverage. You can implement a waiting period before an employee can join your plan. Usually it's a 90-day waiting period. Next, I'll review some benefit policy tips to help with your benefit policy creation. You want to be sure that you clearly detail the premium split. So, for example, will your premiums be 100% employer paid, or will you split the premiums 50-50 between your company and the employee? You may want to check with your carrier, because sometimes the carrier will put stipulations on how much the employer must pay towards their plan. And next, you want to be aware that you cannot reduce or eliminate benefits without providing reasonable notice to employees. In my section on termination, I'll talk a little bit about minimum notice requirements that can be used as a guideline. Also, you want to have a clear policy on how long your supplemental health and dental benefits will extend if an employee is off on a long-term disability. So typically, Canadian companies will keep employer-sponsored benefits going until the employee starts long-term disability, so about 4 months or 26 weeks. Some employers will extend for 24 months or longer, but without a limit clearly indicated in the employee contract on how long your medical and dental will last for employees on long-term disability or on long-term leaves, you may be covering them for much longer than you think is reasonable, and you'll have difficulty removing them from the health and dental portion of your plan. So think about if the employee's doctor says that they won't be able to come back to work for some huge extended period of time. Be clear in your contracts on when health and dental benefits will end for an employee in that scenario. And lastly, for employees on sick or voluntary leave, you are allowed to pass 100% of the supplemental benefit premium cost to the employee. But again, be sure this is included in your policy upon hire and in your contracts so that employees are aware ahead of time what's expected of them. And now Catherine will talk more detail about the importance of the new hire agreement.
So when should you have an employment agreement, also known as an employment contract? We say always. And again, this remains true as we go into 2018. There was no changes to the employment agreement recommendations that we give you. Canadian law assumes that employees retain all rights unless specifically contracted away, which is very different than at-will employment, which we see in the U.S. However, contracts must also always provide for entitlement at least equal to the minimum standards under employment standards legislation. So, for example, you can't put in your contract that the employee will earn less than minimum wage. If you did do this, it would make the contract void. It's common sense, but I'll say it anyway, as we surprisingly get a lot of clients of ours who do it in the wrong order by accident, and then they get in trouble for it. But always give the employment agreement to the employee and have them sign it prior to them starting the position, if you want the agreement to hold up in court if ever challenged. Also, all contracts need to provide clear consideration to the employee in exchange for them to enter into the agreement. An example of consideration is that the employee will receive a specific salary and benefits for the work that they'll be performing for you. It's also a great idea to make sure that you're providing updated employment agreements every time there's any consideration being provided to your employee. So, for example, if you give a raise, bonus, promotion, or another change, to keep your employment agreements up to date. Courts will not rely on old contracts from 10 to 15 years prior, especially if any employment conditions have changed since the original agreement was signed. Also, always provide reasonable opportunity for the employee to review and or seek legal advice regarding the employment agreement before they sign it. This slide is just a list of a lot of clauses that you could have in your employment agreements. Some are meant for more senior or executive positions, and this slide is just a reference tool for you. So there's a lot to consider in regards to compensation in the employment contract, but I'm going to give you a few that often get overlooked. I think maybe our slides went away, but I know our people will work on getting those back up. So just so you know, Nunzio, it's just showing a main slide and not the slide that I'm on. Anyway, I'll keep talking. So for your employment agreements, if you can please ensure that you've addressed all direct and indirect forms of compensation. So things like bonus structures, commission, incentive pay, vacation, etc. Also, consider other types of compensation, things like membership dues, association costs, and location costs for moving at the company's request. Thirdly, how will the entitlements be dealt with upon termination? Be sure to have clear language so it's understood when exactly rights to entitlements will end when the employee is terminated. So, for example, final commissions will be paid once invoices are paid, or year-end bonuses will not be paid if you're not employed with the company at year-end, etc. It's important to let employees know upfront what will happen upon termination. So turning briefly to restrictive covenants, I'm not going to talk too much about it, but common law in Canada does recognize the duty of employees to protect and maintain the confidential information belonging to an employer, which is a great thing. However, we do recommend you put it in your employment agreement as well, so you're explicitly informing employees of their obligation as well as clearly defining what you as an employer consider and expect to be treated as confidential material. And similar to the U.S., non-competition agreements are generally unenforceable in Canada unless they're super concise in terms of geography and length of enforceability, and that the agreement is only protecting vital information. So generally, a non-solicitation agreement might be more appropriate. And the law in the area of non-solicitation agreements is constantly evolving, but again, the restrictions have to be found reasonable in terms of length and geographic scope. And on a final point, you should never use a blanket restrictive covenant clause. Always tailor the clause to the nature of the position's job duties being performed by the employee in question. As for termination clauses, and just to note that Stacey's going to be discussing terminations in a minute, we recommend limiting with specific language the amount of termination pay the employee will be entitled to upon termination. So, for example, just limiting them to employment standards minimums. Outside of Quebec, this language will help you limit your financial exposure. And of course, you can be creative and add your own termination clause in regards to a fixed entitlement or a formula based on years of service for termination pay, as long as it goes beyond the employment standards minimums. And we do recommend you put in the duty of the employee to mitigate. Finally, you'll want to consider short-term and long-term disability coverage and when those will end. Recent cases have determined that employers are on the hook for long-term disability during the notice of termination periods where not stipulated in employment contract. So make sure you've confirmed with your benefit carrier how long your employee benefit coverage will last when an employee is terminated, and adjust your offer letter and what you put in the termination letter accordingly. So other things you should consider in your termination clauses, again, is what happens if the employee resigns. What are you going to how much notice do you want them to give you? Will you put a probation period in? And finally, you should list the circumstances where termination will result without any pay to the employee, referred to as just cause. And with that, I am going to pass it over to Stacey to talk more about terminations to make that more clear for you.
Great. Thanks, Catherine. So, terminations are an unfortunate necessity at times. So, I'm going to start by maybe surprising listeners today by saying that there's no such thing as at-will employment, at-will termination in Canada. Instead, notice of termination must be given to employees, including temporary and contract and even student employees. And as usual, minimum employment standards vary provincially unless there is cause for termination, which I'll discuss in a little while. To answer a common question first, when an employee terminates, an employer must provide a written termination letter and a record of employment known as the ROE that Catherine discussed earlier. And this document generally has to be provided within 5 days of termination and is usually done by your payroll provider, if you do have a payroll provider, or through the ROE web that Catherine discussed. You should also be aware that different provinces have different stipulations on when the final pay must be deposited when you're terminating an employee. So when you are terminating an employee, you can choose to provide working notice or pay in lieu of notice. So working notice means that you can tell an employee on a Monday that effective immediately they have 2 weeks of work left before their employment terminates. This is done when there are really no security concerns or you don't feel that that employee is going to sabotage your company. Versus what we call pay in lieu of notice, which means that you can tell the employee on a Monday that his or her job is terminated effective immediately, but the employee will get a lump sum payment in lieu of actually working the notice time. Generally, the minimum standard is, but again, it definitely varies on per province, but that the employee gets about a 1 week of notice or pay for each 1 week of pay for each year of service to a maximum of 8 weeks of notice. Also, on top of this, Ontario and for federal employees, the Federal Canada Labour Code would legislate that for employees of certain seniority, a lump sum severance payment based on length of service must also be paid on top of the notice pay. So in Ontario, for this to be true, you have to employ more than 50 employees and have a payroll of over 2.5 million in Ontario. So when terminating an employee, all outstanding vacation pay must be paid and the employee's benefits maintained throughout the notice period. This means the statutory period as well as the common law period if your contracts do not stipulate otherwise. Also, an aside, but I feel it's important to mention, if an employee provides you with 2 weeks' notice that they're quitting, and if you, for security reasons, ask the employee to leave immediately, you're still responsible for paying the employee through their notice and to continue benefits until the end of the notice period, unless you have a clearly worded clause in the employee's offer letter stating otherwise. And lastly, you cannot change any conditions of employment during the termination notice period. So, for example, you can't decide that because that person's leaving anyway to reduce their hours or their responsibilities. So next, distinct from minimum employment standards, but extremely important when you're determining the appropriate notice to provide a terminating employee, is common law. So common law is based on legal precedent and increases the notice periods that should be given to employees. So for example, for many high-level professional positions, a common law practice may be to provide around a month worth of notice instead of a week for every year of service. However, in Canada, you have to treat every termination as unique and handle it accordingly and as consistently as possible across your company. So tied to common law notice are the individual characteristics of the particular termination that you're dealing with, which will also affect how much notice to provide. So for example, if you're terminating a 59-year-old product specialist who worked for your company for 30 years, the notice of termination would be above a month notice per year of service, since it's obvious the employee would have difficulty finding comparable job due to their age and because their career has been so focused on your specialized product. This employee would need termination payout equivalent to many years' worth of service. Overall, when terminating an employee in Canada, you must pay attention to minimum notice standards, common law, and those list of specifics that you're facing. In many situations, of course, it's wise to get legal advice since common law precedent is changing all the time. So although very rare in Canada, notice and severance pay does not apply if an employee is terminated for cause. So for cause or just cause termination means that no notice or severance has to be paid. It occurs when the employment relationship is severed because the employee has committed fraud, theft, or willful misconduct. Be very cautious though. For cause terminations are very difficult to prove, and you must ensure you've documented and have concrete reasons for it to uphold if challenged. For example, performance problems would be very difficult to justify as a for-cause termination, even if you had documentation. Overall, it's advisable to have a consultant or lawyer confirm that you're taking the appropriate actions before you terminate for cause in Canada. Now we'll go from talk of terminations to discussing the beginning of the employment process. So some recruiting tips and trends. So, the first part of screening any candidate, of course, after reviewing their resume, is the interview phase. So, in Canada, employees are protected by our human rights legislation, provincially and where applicable federally. And like the US, they are protected against discrimination in hiring decisions. You can't discriminate based on race, national or ethnic origin, color, religion, sex, age, and a whole host of other protected grounds. Just be aware that different commissions across the provinces will have, human rights commissions will have different legislation. So just be aware of what needs to be protected. And to avoid issues of discrimination in your interviews, here's a few important measures you could put in place. Avoid misrepresentation. So don't overstate the position. There was a famous case where the people told the applicant that they would have a job for life, and that was taken into consideration when the employee sued them for wrongful dismissal. So make sure you're not overstating the position. Ensure that all candidates are asked the same questions. By doing this, you help eliminate the candidate allegation that they were treated differently. You want to ensure that you don't engage in idle chit chat regarding marriage, kids, religion, or other protected grounds. Although this seems like innocent banter, it's all too easy for an unsuccessful candidate to allege that you didn't hire them for one of those protected reasons. So it would be up to you as the employer to provide proof to the courts that you didn't actually discriminate against that person. And finally, document everything. For example, the decisions for hiring or rejecting candidates, and make sure that they're legitimate and fully job related. Here's just a slide. Many clients ask us some of the best locations for posting in Canada. Here's a bunch that we use and have found fairly successful, just for your reference on the slide. And Ontario has also recently implemented a legislation under the Accessibility for Ontarians with Disability Act, the AODA, under the Employment Standard, and that requires employers to notify candidates about the availability of accommodation during recruitment, provide assessment and selection materials in an accessible format, and notify successful candidates of the policies for accommodation of employees with disability. And now I'm just going to pass things back over to Catherine to finish up a little bit of today's webcast on the mandatory trainings in Canada, like the one we just talked about, and also some Ontario ESA changes in 2018.
Great. So, yeah, we're almost finished here. I just wanted to highlight to those of you listening who have employees in Ontario that Ontario is the strictest province for mandating trainings that employers have to have done with their employees, and those trainings are listed on the slide. For more information on any of the above trainings or for help creating or rolling out these trainings, please reach out to Stacey or I directly. The next few slides, and we'll just flip through them, are just a reference for you because you will have a copy to the slides on the many, many changes that happened in Ontario in 2018. And then the slide that you're looking at right now also. Yep, that one. That slide also gives a link for the Ontario changes, and Alberta had quite a few changes as well. So I included that link for you. And with that, I'm gonna pass it back over to Stacey, who's gonna finish up with our last slide, and then we'll go to Q&A.
Sounds great. So just now that you're aware of a lot of the legal complications and legislation that is in Canada, whether you have employees in Canada or more for people who are in the States or somewhere else who are looking to employ in Canada, there are several options available to you. So one, of course, is to hire an independent contractor in Canada, who by definition is self-employed, so that does remove the tax deduction remittance responsibility from you. And it can be a great solution if that worker, like in the U.S., is truly an independent contractor. So just note that if you do misclassify your independent contractor in Canada, that there are penalties, and you would be stuck paying the back taxes and other penalties in cases like that if the employee is not truly an independent contractor. If they are in fact an employee, you could set up your own Canadian entity, as Catherine mentioned at the start of the presentation, and that requires setting up the Canada Revenue Agency business number, as well as the workers' compensation, understanding the provincial health and safety requirements and training, and many other things about employing a Canadian yourself. And a final option, and possibly more feasible, would be the option to use an outsourced or third-party employer, such as HR Options. So in cases where you have a project to be done in Canada, or you have an amazing employee in the U.S. who is moving to Canada that you really want to keep, or perhaps you just want to test out the Canadian marketplace, but you don't want all of those administrative hassles of dealing with the Canadian government, or don't have the time to understand Canadian legislations or human resource processes, a third-party employer can employ those employees for you. So, a reputable outsourced employer will take the burdens of Canadian employment, payroll, group benefits, group retirement savings plans similar to a 401k, and human resource management of employees off your hands so that you can focus on your business. The employee performs the work for you, and the outsourced employer handles the aspects of employment from beginning to end. So, this reduces liabilities like those IC misclassifications and eliminates the potential for penalties of filing taxation incorrectly. HR Options can employ Canadians doing work for your U.S. company or U.S. employees coming to work in Canada. We also have an office in the U.S. which provides third-party employment, outsourced employment, as well as consulting services. So please be sure to visit our website at www.hroptions.ca. So if you're not already set up, hopefully this gives you an idea of what possibilities there are for coming to Canada. And that concludes our talking portion of today's webinar, and I'll turn things back over to Nunzio.
Thank you, Stacey and Catherine. That was great. It's always a pleasure to hear all the information you share with us. But let's jump into Q&A. Quite a few questions have come through. Not sure we're going to be able to answer them all, but like Catherine and Stacey mentioned, if we don't get to your question, please do not hesitate to reach out to us. So Catherine or Stacey, please, either one of you can answer this first one here. If we have associates with vacation hours, but the associates already left the company, what is the procedure for these vacation hours? No, we already include 4% vacation pay on associates' bi-weekly paycheck.
So yeah, so if you've already paid them, if you've paid the 4% with every paycheck, there's no other obligation. The only obligation if the employee is left is if you had an amount of vacation that they had accrued that you had not yet paid them, then you're going to have to pay them. Even though they're gone, you're going to have to reactivate them or directly deposit the money in their bank or send them a check. But it sounds like it's already taken care of because you paid the 4% with every pay.
Got it. And they have a follow-up question to this, and it says every year associates accrue those vacation hours. And now, is it required for those associates to take those vacation hours before the end of the calendar year?
No, so they have most legislation will say they have up until 10 months into the next year around to take the vacation. So I would recommend that as an employer, you're tracking and making sure that they are taking that vacation and they are taking it within 10 months of the following year, or else you would be in breach. And some employers will ask us if they can just pay the employee out. Oh, the employee's really busy. They don't have time to take vacation. Can I just pay them out? No, you can't. Under the law, if you're strictly going by the law, you'll have to pay them vacation time. Sorry, you have to pay them the vacation, but also give them the time off.
Got it. Okay. Next question here is, can I have the slides? Actually, you know what I'm going to do, everyone? I'm going to push out the slides and a few one-pagers to your chat box. So I'm going to do that right now. 1, 2, 3, 4, and 5. You could download that at any time. So next question here. What employer tax issues exist when an employee lives in one province but works in another?
Oh, that's a very good question. There are several tax implications for people who are living in one province and working in another, and generally that you are taxed in the province that you're working in. So I'm not an accountant, so I don't want to go too far into taxation, but in terms of that, you have to make that consideration, and you also have to be aware of that when you're filling out their year-to-date forms, as well as when you're remitting taxes, that you're remitting them to the proper location. So you may want to investigate that depending on where your employee is living and or working.
Got it. Next question here, ladies. If an employee is on leave when the company does a reduction in force, eliminating his or her position, what happens?
Well, that one is fairly easy in terms of if it is an actual business-related necessity that you're eliminating those jobs. It's not anything to do with the employee on leave, and you can prove that it is actually like maybe you're shutting down their whole department, in which case it's legitimate, in which case you would follow the same termination procedures as you would with others who are not on leave. You just want to be very careful to make sure that you have all your documentation in place and that there's no way that employee who is on leave, who's having their job eliminated, would feel that there's a discriminatory case against them. So just making sure that if you are doing an elimination of positions, that they are truly business related and that you can back up that evidence.
Makes sense. All right, next question here. Does employer-sponsored benefits include prescription?
Yes. So yeah, they do. So and again, employer-sponsored benefit plans are not legally required, but as a best practice, almost every employer in Canada will have a employer-sponsored benefit plan for their employees. And yes, a competitive, good standard benefit plan will absolutely have health coverage that covers prescriptions anywhere from usually it's around 80% of coverage up to 100% of coverage of the cost of the prescription.
Your
Okay.
broker can help you develop your plan. Like your broker will help you develop how much you actually want to cover those people and help you build the plan that's best for your amount of staff and number of people and that sort of thing.
Perfect. A few more questions here, ladies. So the second last one here that came through is, so is health benefits a taxable benefit? If so, does that mean we should include the amount on our T4s?
Yes. So if you are in every province, every province across Canada, if you are paying for the employee's portion of life insurance, dependent life insurance, accidental death and dismemberment, or critical illness, the premium plus tax for those benefits are a taxable benefit and needed to be added to box 14 and 40 of the T4. If you have employees in Quebec, and so already those have to be included in box A and L of the relevé. But if you're in Quebec and you cover health and dental for the employees, this is only for Quebec, then that portion that you pay on the employee's behalf is also taxable in Quebec for provincial tax only and QPP, and that has to be reported in box A, and I believe it's J. Don't quote me on that for sure. I think it's J, but just so you know that yes, those are taxable benefits. They need to be included at income generally at the time they receive the benefit, so probably on a biweekly basis, and then at year end they need to be reported on the proper T4 or a year end paperwork or relevé if it's in Quebec.
Perfect. And the last question here, ladies, how often do employers need to pay employees?
Oh, that's a good question. So in most provinces, you have to pay at least monthly, but then there's provinces where it's illegal to pay monthly and you have to pay at least semi-monthly or biweekly. And I know Quebec, you are not allowed to pay monthly. You have to at least pay biweekly or semi-monthly, but most other provinces, you can pay monthly. However, the best practice is to pay either biweekly or semi-monthly. That is by far the most common.
All right, and I lied to you. There was one question that just sneaked in right now, and I feel bad leaving it unanswered. If we have an employee who has a no call and no show and never shows up again, what is the procedure to handle this case?
Right. So this is generally referred to job abandonment. So if the employee just doesn't show up for work on their shift, doesn't give you any explanation, they just haven't showed up. Maybe the next shift you've tried to reach out to them, there's been no comment from their side. We always suggest sending a registered letter to their home that they have to sign for that says, we haven't heard from you, we're concerned about you. We're assuming at this point if you don't reply to us by a specific date and give them some time, and then that you are no longer interested in this position, and we'll make this would be considered a job abandonment or a voluntary resignation. And then if you don't hear from the employee, then at that point, after you've done that, the registered letter and everything, you can feel free to terminate that employee as a voluntary resignation.
Got it.
Well, you would owe them owe no funds. But be careful, because we've been in this situation a few times where you do actually hear back eventually from the employee or a family member, and they were in the hospital, so don't just fire them without giving them that chance via the registered letter. And every other means of trying to get in touch with them, text, voicemail, give them that chance, usually at least a week from when they get their registered letter or communication to let you know if there was some kind of extenuating circumstance.
Makes sense. Well, ladies, thank you so much. This was great. We are out of time for today. Like I said, I did share all the slides in the one pager, so please download them and review them on your own time. But I definitely look forward to connecting with you all and seeing you all on future webinars. Thank you for spending your afternoon with us, and have a great day. Thanks, Catherine. Thanks, Stacy.
Thanks, everyone. Bye, everyone.
Bye.